Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortune of others. As always, I hope you will appreciate this legal education content, and today may be the day I earn your subscription. For our live story today, we are doing the latest in the CDC extension for the moratoriums on evictions of housing. This is the fourth such order the CDC has issued. And it's clearly illegal. I can count votes at the Supreme Court. I have a case which is actually these exact same parties. It's Alabama Association of Realtors versus United States Department of Health and Human Services. Same parties. Already been to the Supreme Court, right? And in that case, I have 4 votes to undo the stay. Right, so the lower court had issued a stay. They said that it was illegal, but they issued a stay. So it's illegal, but the judgment stayed, right? And so it went to appeal, and I have 4 votes that say we would end the stay. And I have a 5th vote, driven by Kavanaugh, which says in so many words, I will not issue the stay, or I will not end the stay, because this is already going to expire in 3 weeks. And we can let it come to a more orderly end by just simply waiting. And in order to extend this, you're going to need the vote of Congress. Now, there was a case called Marks. And Marks tells me how to count splintered votes, such as this, right? So I don't have any opinion from the Supreme Court that has 5 votes for it. So how do I determine what is the majority holding? Well, Marks tells me the answer to this question. Marx says what you need to do is you need to look for the lowest common denominator. What is the thing that you can find 5 votes on that would be something they can all agree on, right? So 4 votes say, end it right now. A 5th vote says, we're not going to do anything about it right now, but they had need in order to extend. So what is the least common ground? They need in order to extend, right? Because if it's illegal right now, right? That's what the 4 votes said. It's illegal right now. The 5th vote says it would be illegal as of July 31st without Congress. So what's the least common denominator? It's illegal as of July 31st without Congress. It's not a lot of work to count those 5 votes. But, the CDC published a new eviction moratorium anyway, for reasons. Okay. So that happened. And so Alabama Association Realtors is back at the district court and says, we'd really like you to vacate that order from the CDC as being in violation of the U.S. Supreme Court. Yeah. I can get the 5. So we're going to read their argument and discuss it, and then we'll also discuss an amicus brief because it's interesting and hilarious. So let's do that. Okie doke, here we are. Again, in the United States District Court. Again. Emergency motion to enforce the Supreme Court's ruling and to vacate the stay. The Centers for Disease Control 4th extension of eviction moratorium until October the 3rd conflicts with Supreme Court ruling the CDC could not extend the moratorium beyond July 31st. That does seem to be the result that Marx would suggest. If 4 people say it's illegal right now, and 1 person says it would be illegal as of July 31st, then 5 people agree it's illegal as of July 31st. That'd be the least common denominator, right? After this court entered final judgment holding the eviction moratorium is unambiguously foreclosed by the plain language of the Public Health Act. Yeah, I've read it many, many times. Many times. It says the CDC has the power to cleanse things, to sanitize things, to destroy tainted articles, and so forth and so on, right? Things of this nature. And then it says, and other stuff. And we know what to do. When we have in law and other stuff, we read the and other stuff in the light of the stuff that preceded it. It doesn't mean all other stuff. This is well established. It means other stuff that are like, that were in the same nature as the stuff that we've talked about. So, okay, we have sanitizing things, destroying tainted articles, we can force people out of their homes, but not into their homes ideally. And also one of those things that's like those things is an eviction moratorium. That doesn't make any sense to this lawyer's head. It's not anything close to like it. So, yeah. And then, here's what Kavanaugh said, right? Because he's the only one who wrote an opinion. The four other people didn't write an opinion. They just said they would grant it. Right? So Kavanaugh's the only one who wrote an opinion. He says, because the CDC plans to end the moratorium in only a few weeks, on July the 31st, I vote this time to deny application to vacate the district court stay. And Justice Kavanaugh explained his controlling opinion, because Marx, so yes, because the CDC exceeded its statutory authority in issuing a nationwide eviction moratorium, clear and specific congressional authorization via new legislation would be necessary. I mean, that seems like the controlling vote to me. I've got 4 people who say, I want to do it right now, but no opinion. They don't write anything. They just say, we'll do it. And 4 people will say, we won't do it. And one person says, I don't want to do it right now, but it's going to come to its end, and Congress. Seems like the controlling vote to me. Okie doke. As the date approached, the White House repeatedly stated the Supreme Court ruling had unequivocally blocked the CDC from extending the eviction moratorium. They sure did. Taking a cue from Justice Kavanaugh's controlling concurrence, Congress attempted to pass legislation but failed. After Congress's failure to extend the moratorium, the Speaker of the House and other representatives demanded the CDC extend the moratorium through executive action anyway. Now, I would be slightly remiss if I didn't point out that every single member of Congress takes an oath to uphold the Constitution and the laws of the United States. And one of the laws of the United States is judiciary and their ability to rule on things, at least since Marbury versus Madison, for sure, And so Congress should be listening to the Supreme Court. But instead, they're calling on the CDC to do things the CDC can't do. And they're also encouraging illegal acts. Thus began a tidal wave of political pressure put upon the CDC. One member of Congress dared the CDC to do it. Who was going to stop them? Who was going to penalize them? At Representative Maxine Waters. Well, one of the people who could stop them and penalize them would be you, Representative Maxine Waters, as I just mentioned just now. You took an oath to uphold the Constitution and the laws of the United States. And Congress has oversight authority on the executive agencies. So one of the people that could stop them and one of the people that could penalize them would be you. And I would suggest that you should, because, the Supreme Court said that's not in the law. I tend to agree. I've read it a couple times. I can't find it either. So one of the people that should stop them is you. Instead, you're calling for the CDC to do it. So either you don't know how to read a Supreme Court opinion or you don't care. That's really great. But on August the 3rd, the CDC caved to political pressure by extending the moratorium without providing any legal basis. It would be hard. They tried to, incidentally, but no. In substance and effect, the CDC's latest action is an extension of the same ban, pretty much. Indeed, the fourth extension relies on the same source of authority, Section 361 of the Public Health Act, which we have read several times, and I've just, giving you the summary of. The CDC has the power to sanitize things and, force people out of buildings that are tainted and destroy infected articles and so forth and so on. Not so much with the stopping of the evictions. The CDC's semantic recasting of the latest extension, which covers 90% of renters, while leaving intact its ability to cover ratchet up to 100%, is a distinction without authority. I agree. The Supreme Court, this court, that would be the district court in this case. The district court should immediately vacate the fourth extension because it conflicts with the Supreme Court. Yeah. A majority of the Supreme Court made clear the eviction moratorium exceeds CDC statutory authority and could not extend beyond July 31st, thus vindicating this court's first merits ruling. I mean, that's the way I count the votes. You want to know how stupid? Do you want to know how stupid? And we're not going to read it because I don't want to expose you to this amount of legal stupid. I did it so you don't have to. The government has filed a response. To this. And among other things, they said, hey, Alabama Association of Realtors, you can't count dissenting votes to get you to 5. I don't know why you're counting dissenting votes to get you to 5. Why are you counting those dissenting votes to get you to 5? Yeah, it's a pile of stupid. It's like I'm not counting any dissenting votes. I'm not. I'm counting the 4 people who said yes and the 1 person who said yes but not now. And 4 other people said no. And I'm like, okay, all right. The Supreme Court's ruling was hardly ambiguous. Indeed, the White House clearly acknowledged the Supreme Court had ruled on the CDC's lack of authority to extend the moratorium, and the CDC was blocked from extending it. Yeah. I mean, Joe Biden is a lawyer, so, yeah. And if he needed another legal opinion, there's no shortage of them to be had. Yeah. Because the CDC's August 3rd extension conflicts with the Supreme Court's ruling, the court should enforce that ruling by vacating the extension and or vacating this. Yeah. Expedited relief vacating the extension is appropriate because the CDC appears to have acted in bad faith. Yeah. The Supreme Court has ruled only the legislative branch, not the executive, had authority to extend the moratorium. Chevron does have its limits. Thank God. As small as they are. Critically, the CDC knew the White House repeatedly stated new legislation was necessary to extend the moratorium given the absence of legal authority. Yeah, here's a secret for you. The executive executes the laws that are already in place. See, the executive doesn't create new law. It executes the law that's already in place. If you want to create new law, you would go to the legislative branch. That's what they do with their time. They are the ones who create new law. The executive executes that law, and the judicial branch judges what the law is. This School Rock House summary has been supplied to you by Uncivil Law. Yet, rather than accept as the final work under our constitutional system, which the White House initially appeared to do, the CDC extended it anyway. And the CDC did it for nakedly political reasons, to ease political pressure, which, whatever. Shift the blame to the courts for extending it, yeah. And use litigation delays to achieve the policy objective. I'm not so sure how effective those delays will be. As I've pointed out a couple times, the Supreme Court can really, really move when it's motivated. And this might be one of those times. The court should block the August 3rd extension on expedited basis to relieve nation's property owners of burdens with complying with unlawful action. And then, of course, the undersigned counsel conferred with the other counsel, which is required by the rules. And amazingly, the U.S. government opposes this. Yeah. So let's learn a little bit more about this. On May the 5th of 2021, this court held the Public Service Act unambiguously forecloses the nationwide eviction moratorium. Now, I would be slightly negligent as a legal educator if I didn't point out the D.C. Court of Appeals disagreed and said the CDC could do this. I'd also be negligent if I didn't point out they were the only court of appeals that said that. Every other court of appeals that looked at it said no. The DC Court of Appeals looked at the statute and said, yep. Now, I've read their decision too. It makes absolutely no legal sense to me at all. It doesn't work. So I would imagine the best argument for the government here is, well, strictly speaking, there's no binding decision from the Supreme Court, which is being a bit disingenuous, but technically correct, I guess, in some sense. And the Court of Appeals has already ruled this extension is okay, so the district court has no choice, which might be true, which doesn't really matter for the purposes of getting this before the Supreme Court, right? So either way the district court goes on this, whether it says, in a technical sense, the DC Court of Appeals decision is still binding on me because the Supreme Court didn't technically come out with an order. Yeah. So, or, no, I can actually count to 5, so I'm going to do that. Regardless of it, the Supreme Court has this wonderful move. It's in the rules. It's called certiorari before judgment. In this case, before judgment means before the judgment of the Court of Appeals. Because you see, the Supreme Court can't act as the court of first instance, except in some limited situations, which are specifically mentioned in the Constitution, and this is not one of them. Right? But the Supreme Court can act as a court of appeals. Right? I mean, yeah, that's kind of what it does with the time. And it can act as the direct court of appeals. So either way this district court goes, right, whether they say yes or they say no, the Supreme Court can say, and then they file an appeal. The Supreme Court can say, that's interesting, yoink, that's our appeal now. Right? That's our appeal now. We're just going to skip the DC Court of Appeals because we can. We want to hear this right away. And depending on whether or not John Roberts wants to really be a dick that day, because he is the circuit justice for the DC Court of Appeals, right? All the justices are split up among the many circuits, and depending on what circuit it is, one of the justices is assigned to it. In the case of the DC Court of Appeals, the circuit justice is John Roberts. So technically, if he wanted to be a real dick and he wanted to, if he wanted to get some cred with the right, if he really wanted to bring his big boy pants that day, technically speaking, John Roberts can yeet it out of the district court and rule on it himself. He can say, oh, that's interesting, affirmed or denied as the case may be, because I'm the circuit justice, go to hell. And we clearly can count this, and I don't need to refer to the rest of the Supreme Court. That might be fun. Now, John Roberts doesn't seem like the kind of guy who would pull that trick. I'm just saying it's possible. So maybe if John Roberts gets his big boy pants on, maybe he'll go for that judo move and get some credibility back with the right wing. That'd be cool. The court, this would be the district court, rejected government's assertions so long as the CDC can make a determination the given measure is necessary to combat spread disease. There's no limit of authority. No. As the court explained, construing the law to extend a nearly unlimited grant of legislative power to the secretary would not only would ignore the text and structure, but would raise serious constitutional concerns, including legality of such a broad delegation unbounded by clear limitations and principles. Yeah. In addition, the court observed accepting the government's expansive interpretation will require embracing the implausible assumption that Congress delegated to the secretary the authority to resolve not only the momentous decision to criminalize evictions nationwide, but endless others that are also subject to earnest and profound debate across the country. Because Congress did not express clear intent to confer this authority, the court declined to take that step. The court therefore issued a judgment vacating the moratorium. The court nevertheless issued a stay of its order pending appeal, which is very typical. When they say you're going to appeal, it's very typical. Now, sometimes the district court can be a real jerk and say no, and I kind of hope this is one of those times too. No, how about no, I'm not going to issue the stay. Ask the appellate court for your stay. I'm not giving you one. I don't blame the D.C. Court of Appeals, by the way, for issuing the stay in the first instance. It's a perfectly reasonable thing to do. It's perfectly fine. It's almost expected. But it would be kind of nice if this time they said, yeah, no. But relying on D.C. Circuit precedent, the court determined it could employ a sliding scale approach under which the government needs to raise only a serious legal question if other factors strongly support a stay. As the court explained, the government had met this less demanding standard in part because 2 other district courts had disagreed with the court's analysis, at least the preliminary injunction stage. Turning to the equities, the court acknowledged the stay will no doubt result in continued financial loss to landlords, which remains severe, but the court decided equities favor the government on the theory that some of these losses could be recovered, because one of the things when you're deciding whether or not to issue an injunction is, will money fix the problem? If money will fix the problem, then you're never going to get an injunction. Now, you could very easily say that money won't fix the problem because not all these people have money. But, So the court said that it met the standard because there are some losses that could be recovered. So some people might be able to pay the landlords. And public health considerations are important, which is fair. The D.C. Circuit subsequently denied the motion to vacate the stay in an unpublished opinion. So the D.C. Circuit couldn't even be bothered to write an opinion, which, I guess, if there's nothing to say, there's nothing to say. The Court of Appeals for the Federal Circuit is known for doing this quite frequently on patent cases, quite to the irritation of some members of the patent bar, where they just say, we affirm, and they don't say anything. So, Okay. So D.C. Court of Appeals said, that sounds right, we're good, with no explanation. All right, fine. Which I suppose technically means there's no binding decision from the Court of Appeals, because they didn't issue a ruling. If they'd issued a ruling with an opinion that provided rationales, right, those rationales would be binding. But they didn't. So you could take the position that there is no binding authority from the district court or Court of Appeals. So, yeah, that might be a thing. There is a change in facts. So, yeah. After plaintiffs asked the Supreme Court to vacate the stay, the CDC extended the eviction moratorium for a third time. In issuing the order, the CDC stated, although the order is subject to revision based on changing health, albeit unexpected change, the CDC does not plan to extend the order further. That might have been a lie. The Supreme Court relied on this assurance from the CDC when it denied plaintiffs' application. 4 justices, Thomas, Alito, Gorsuch, and Barrett. Okay, so I apologize. There's no hope. I apologize. There's no hope whatsoever that John Roberts is going to get on his big boy pants. I'm sorry, he was in the dissent. So remember how I said technically John Roberts could issue a decision by himself? He wasn't in the majority. John Roberts has been a bit of a disappointment to some of us on the right. Yeah. Thomas, Alito, Gorsuch, and Barrett would have granted the application. So they would have said, yes, now. Because plaintiffs carry their burden to demonstrate the CDC exceeded statutory authority in issuing the memorandum, and equitable factors did not justify a stay. This is because under Supreme Court practice, a circuit justice, and that would be, in this case, Roberts, may vacate a stay when it appears the rights of the parties to the case of the Court of Appeals, which could and likely would be reviewed here, may be seriously irreparably injured. The circuit justice of the opinion is demonstrably wrong in accepting the issue to stay. And the accepted standards for issuing a stay are a stay may be granted only when the movement has a strong showing that's likely to succeed on the merits, will not substantially injure the part in public interest favors the stay. Yeah, this is the same 4-part standard we see everywhere. MR Bima says Kavanaugh causes. Well, I don't know that's strictly speaking true. And I have taken a much more accepting position on what Kavanaugh did than some other people. And I'll explain my reasoning for what it's worth. One of the courses you do in law school is called remedies. So in remedies, the entire premise of remedies is you've already had the criminal trial, you've already had the civil trial, guilt or liability has been found, as it were, right? So premise, a court has already ruled someone did it bad. The entire point of remedies is, okay, now what? Right? Okay, now what? And in remedies, you discuss, okay, now what, into some varying degrees. And to my mind, Justice Kavanaugh's decision makes a lot of sense. His rationale, at least the way I parse it, because he didn't say as much, but here's how it makes sense to me. Or how it would make sense if I were writing that decision, maybe. He says, or I would say, look, this moratorium has been in place for quite some time now, right? And one of the things that you look to in the stay factors is the public interest, right? That's the fourth factor. What is in the public interest? So, will something else fix it? Will something else fix it? How much have you been harmed? How much has the other party been harmed? And what's the public interest? So for me, you say, okay, look, this has been going on for quite some time now, for better or worse. And for better or worse, people have built their lives around this, right? And they built around the expectation this will not be extended because the CDC said so, right? So the expectation is this will last until July 31st, and then it will end. And it's, at the time the Supreme Court's writing this decision, it's like July 10th or something, right? So I think Kavanaugh looks at the balancing factors and says, look, the public has collectively, for better or worse, said or taken note of this and built their expectations around. And it's going to end in 3 weeks anyway. So let it just come to its natural end. People have already built around that. To end it right now might be disruptive. It's going to end in 3 weeks. So let it expire by its own natural terms. Now, I think that's a perfectly reasonable decision, particularly on the equitable factors, which you're considering under. When you look at reliance interests, and like, okay, people built their reliance interests around this, landlords and tenants alike. And so let it come to its natural end. It's not 3 months from now. It's not 3 years from now. It's 3 weeks from now. So I thought Justice Kavanaugh's decision made sense using the relevant law, the equitable standards, the 4-part test you're supposed to use. Right? This is a 4-part test. We've gone over it. And I was like, okay, I see a problem, but I'm just not going to do anything about it right now because it's going to come to its end anyway in 3 weeks. So, let it come in 3 weeks. That made sense to me. So, but, Roberts being in dissent, I'm much less charitable to that, because it's clearly illegal. It's clearly illegal. I don't want to do anything about it right now. I totally understand. I totally get it. But I don't want to do anything about period like Roberts, or even Kagan for that matter. Yeah, and I don't see Kavanaugh doing that again. And John O'Brien has it completely right. Is the harm capable of repetition to avoid review? That's completely right. I think the odds are very high the Supreme Court will take review of this. Now, whether or not they want to ball their ass out to issue a decision, quickly or not, who knows? It's extraordinary in every possible sense. It doesn't happen very often. It's rare. But, the Supreme Court might pull the trigger because they might feel like they've been directly defied, and the Supreme Court really doesn't like that. So they might want to smack some people around. But even if the Supreme Court, doesn't do it immediately, and they grant cert, and it's not going to be heard until October 3rd, I would be very surprised indeed if a mootness argument will work. Oh, it's moot, Supreme Court. Oh, it's after October 3rd. It's moot. I don't see that working at all. Capable of repetition yet evading review. Capable of repetition but evading review. The Supreme Court is probably going to go, no, not so much for the mootness for you today. No, not so much on the mootness today. We definitely want to whack you around. So, yeah. So that'll be fun when it comes. And Mr. Bima says, I think it could be disruptive to start it up again. Yes, I agree. It was disruptive to start it up again. The Supreme Court seemed to indicate fairly strongly to my mind they didn't want that to happen. But the CDC over here is like, we don't know how to read it. Anyways. So here's exactly what Kavanaugh wrote. Because we've only been quoting it in part. It's not very long. It's a paragraph. So 4 justices just say we would grant it. And here's what Kavanaugh says. In a concurring opinion, right? It concurs. So 4 people say we would grant this, which means implicitly we think it's illegal and we want it to end right now. That's what that means implicitly. They don't have to write it because that's just what it means, right? We think it's illegal. We want it to end right now. So Justice Kavanaugh is writing a concurring opinion. I agree with the district court and applicants. The Center for Disease Control exceeded statutory mandate. So I agree it's illegal. Because the CDC plans to end the moratorium only a few weeks on July 31st, and because those few weeks will allow for additional and a more orderly distribution of Congressly appropriated rental assistance of funds, I vote this time to deny application to vacate the stay in order. Right? So it's like, it's going to end anyway. People build a reliance around let this come to its end. In my view, clear and specific congressional authorization via new legislation would be necessary for the CDC to extend the moratorium. And under Marx, which is the case that tells you how to count split votes, so when you don't have a majority for any one proposition, how do you count split votes? Well, my reading of Marx onto this is the controlling opinion. This is the one that binds us. So, with 5 justices agreeing the CDC lacked authority, Justice Kavanaugh's controlling opinion made it clear they couldn't extend. That's the way I count it. On July 29th of 2021, the White House announced the CDC would not extend the eviction moratorium because the Supreme Court has made clear that this option is no longer available. In June, when the CDC extended the eviction moratorium until July 31st, the Supreme Court's ruling stated that clear and specific congressional authorization via new legislation would be required for the CDC to extend. The White House, statement by the White House press secretary. The White House said, in light of the Supreme Court's ruling, the president's going to work with Congress to make that happen. The White House press secretary. In response to this announcement from the White House, the House of Representatives tried and failed to pass legislation extending the eviction moratorium on a short notice, which incidentally they did do once. Well, not exactly extend. They retroactively made it legal. So they did that once. They retroactively made it legal, which the Supreme Court can do. Right? They can't retroactively make something illegal, but they can retroactively make something legal. So yeah, they did that in January, I think. After the House failed to pass legislation, the focus shifted onto the White House, where the president announced the eviction moratorium would expire the next day. As the eviction moratorium deadline approaches tomorrow, I call on the state and local governments to take all possible steps to immediately disperse funds, given the immediate ending of the CDC. Yeah. Then, after the eviction moratorium expired, the White House reaffirmed on August the 2nd that the CDC lacked authority, although the president would have strongly supported a decision by the CDC to further extend the eviction moratorium. Why? The Supreme Court declared the CDC could not grant this absent new legislation. So why would the White House or the president have supported a decision? Why would the president strongly support a decision by the CDC to extend when they also say, the White House says, the Supreme Court said they can't do that? So why would they approve of the CDC doing something that they acknowledge the Supreme Court said is illegal? Why does the president want the CDC to break the law? At a press briefing the same day, the White House maintained its view the CDC had no authorization to extend without clear and specific authorization. To date, the CDC director and her team have been unable to find legal authority, even for a more targeted eviction moratorium that would focus on counties with higher rates of COVID. Yeah, I looked too. I mean, I'm certain I didn't look as thoroughly as the CDC, who I'm sure scoured every inch of the health law, but I couldn't find any. During the same briefing, the senior advisor to the president said the CDC tried and failed to find legal authority after double, triple, and quadruple checking. I'm sure they read the health statutes very, very carefully. Very, very carefully. He explained the president asked the CDC to look at whether you could even do a targeted eviction moratorium that just went to counties with higher rates, and they, as well, have been unable to find legal authority for this targeted moratorium. He also acknowledged the wording of the Supreme Court was fairly, clear. They said the CDC could not grant the authority without, quote, clear and specific authorization. Yeah, I didn't see a lot of ambiguity in that Supreme Court decision. Seemed pretty clear to my legal mind, pretty clear to my legal mind. As late as August 3rd, the White House stated the CDC lacked authority to extend because the Supreme Court came out and said they put a stay on the moratorium and made clear in their writing, which is available to everyone, that any further action would need a legislative step. It also mentioned the third extension of the moratorium the CDC has done since January would be the last extension, and expressed concerns about what the impact could be on long-term capabilities. Authorities, they say, of the CDC. The CDC has just as much authority as it always did. It's simply this wasn't one of them. Yet later that same day, the CDC relented by extending the eviction moratorium. Now, the president of the United States could, tell the CDC not to do that. He's the president of the United States. He could give an order to the CDC. But, the new order had the same effect as the moratorium vacate, except it only applied in counties with heightened level of community transition. As the CDC acknowledged in its order, over 80% of U.S. counties were covered by this extension, however. And according to the president, latest iteration covered close to 90% of American people are renters. So only heightened, but 90% of the people. So, yeah. Not surprisingly, the CDC order contains no discussion of the agency's authority to extend, other than to note the order was poorly issued under Section 361. Which, I don't know how. In announcing the extension, the president conceded the courts had already made it clear the existing moratorium was not constitutional, it wouldn't stand. The president announced the bulk of the constitutional scholarship says it's not likely to pass constitutional muster. Yeah. The CDC, yet the president candidly acknowledged that by issuing the extension without legal authority was a delay tactic because by the time it gets litigated, it will probably give some additional time while getting that 45 billion people out to people who are in fact by their rent. Openly acknowledging that you're doing this, specifically because it will take time to litigate, strikes me as one of the clearer statements of bad faith I have seen as a professional. What reason did you do this? Well, it's going to take so long to get litigated, at least we'll get more time. That strikes me as one of the clearer statements of bad faith I can imagine. Please make me a federal judge. Please. I'd be a great federal judge. I'd issue this one so fast, it'd make your head spin. Unclassified name gives me $49.99. Thank you very much for the very generous super chat. It is always appreciated. Support for you, keep up the fight. Yeah. You know, I'd tell you if I saw it differently. I have from time to time displeased the chat by giving them opinions they didn't want. For example, some people might have been displeased with my opinion as to Kavanaugh and what he did and its propriety. You know, I accept that as a possibility. I'll give you my opinion regardless, because that's how I roll. You know, but regardless of what Kavanaugh did, the CDC is completely full of shit. And it irritates me very much, because I'm like, I can read. A district court has inherent power to enforce its decrees. Yeah. A stay may be granted and remains in place only when the government's made. So here's this again, the standard for stay, right? Here's the standard. It's the same standard as for an injunction, right? It might be worded slightly differently. Some circuits word it a little bit differently, but it's essentially the same 4-part standard as an injunction, because a stay is an injunction. It's an injunction against it going into effect. So what is the standard for a stay? A strong showing as the likelihood of the merits. Kavanaugh got you there. Irreparable injury absent a stay. Unclear what Kavanaugh thought there. A stay will not substantially injure other parties interested in the proceedings. Unclear. And factor 4, which is definitely going to carry the day, the public interest favors a stay. I think that's right. I think for better or worse, people have built expectations around this. There's a strong reliance interest, but it's going to come in end in 3 weeks anyway, so why bother? Let it be. This I understand. All parties agree the Supreme Court ruling blocked the CDC from extending the moratorium because clear and specific authorization would be necessary. There's no question the CDC's extension conflicts with the Supreme Court ruling because Congress did not pass another extension. The only question is, what should the court do about it? I'll tell you what the Uncivil Law court is ready to do. Where can I just get out my vacate stamp? How hard can I stab the paper multiple times? Can I just issue like a 30-page decision, and all 30 pages are nothing more than the vacate stamp just being repeated over and over and over in all kinds of orientations? You know, some will be straight on, some will be crooked, some will be upside down, some will be with a smiley face. It'll be 30 pages of vacate stamps. I'm ready to go. I feel like I don't need any rationale at this point. Yeah, I feel like the Supreme Court's kind of done that for me. Just see what they said, you know? Justice Kavanaugh's controlling opinion was clear. The executive branch agrees. As the White House explained, the Supreme Court's made clear that's no longer available. Yeah. To enforce the Supreme Court's ruling, the court should either clarify that its order vacating the moratorium, extension of the moratorium, or an alternative vacate the extension. I'd go with the latter. I mean, I'm not sure it technically makes a difference either way, but, well, maybe I'll just do them both. I'll vacate it as an extension and an alternative vacate it onto its own self. I'll just vacate it both ways. What the hell? All the vacating. The August 3rd extension is materially the same as the moratorium vacated by this court and reviewed by the Supreme Court. Like each prior iteration, the 4th extension provides property owners shall not evict any covered person, which is anyone who says they're too poor to afford their pay or something, during the effective date. The CDC relied upon the same authority, and this court, the majority Supreme Court, failed to provide authorization, Although the 4th extension applies in counties experiencing substantial and high levels, that's apparently basically all the counties. To view the extension as a new order would require this court to exhibit naivety from which ordinary citizens are free. You know, either way. It's an extension of the old, it's a new one, I don't care, I'll vacate it both ways. You know, it's like a chef. It's like a chef. You know, today, I'll be serving you chicken 3 ways. You know? So this Chef Judge Mueller says, today I will be issuing an order of vacate in 2 ways. Flambéed and fried. Ooh. Ah, Master Chef worthy, baby. Even if this extension did not conflict with the Supreme Court's ruling, which this court should still clarify it's covered by the vacator or simply vacate it for the same reason. Yeah, I'll do all those things. I'll just do all of them. It's invalid as being an extension of. It's an extension being part of. It's an extension as a thing unto itself. It's invalid just any way you slice it. It's invalid all the ways. Expedited relief is particularly appropriate because the CDC appears to have issued it in bad faith. You think? You think? Over the course of 5 days, the White House repeatedly stated the CDC lacked authority, yet the CDC issued the extension without attempting to invoke a new source of authority. The extension of the moratorium rebuts the presumption that officials of the executive branch will adhere to the law. You think? The courts have the big stick, and this court is ready to use it, man. I will beat them down. I will beat them with my stick. Yeah. Moreover, the CDC's explanation for the extension is incongruent with political reality that they extended it to receive political pressure and used litigation delays to buy more time. This judge is having none of it. In fact, the president himself stated as much by saying, by the time it gets litigated, it probably gives us some time where we're getting that $45 billion out to people. If this judge had anything to say about it, the litigation period's over now. It was a short litigation period. It's over now. The inability to administer a rental assistance program does not statutory authority create. Yeah. The CDC's decision appears to have been made for political reasons. Indeed, the White House announcements that CDC could not and would not extend the moratorium received a massive blowback from Capitol Hill. Guys, I'm just a bill. I'm only a bill sitting here on Capitol Hill. Well, I can't wait to go to Congress and for them to approve me and President to sign me so I can become a law. It's like, guys, why are you yelling? Why is the legislative branch yelling at the executive branch? The legislative branch, if for no other reason, the legislative branch should be jealous, and that's precisely the right word, of its own power. Right? The Congress creates law. It's like Congress created a law that says do this, and the president is exceeding your mandate. Why isn't Congress pissed that he's doing this? It's like, that's not what we wrote. Why are you doing the thing we don't want to? We didn't authorize. Instead, they're saying, "Hey, it's great that you're defying the law that we, the congressional branch, passed." This is the strangest cell phone ever. Ever. We got the legislative branch complaining to the executive that they're not extending a moratorium, which is not supported by the law that Congress passed. So they're angry at the executive for not going against the legislature. Does the legislature know what their job is? Does Congress understand their essential job function? I'm just a bill, only a bill, sitting here on Capitol Hill, not on sitting here on the White House steps, or sitting here on the steps of the judiciary. Eh? The court should also vacate its order in light of the Supreme Court ruling, and because if the court clarifies the order, cover the latest extension, vacating the stay will be necessary to give relief. Yeah, you can have that. The Supreme Court ruling compels vacator of the stay pending appeal. 4 justices would have vacated the court's stay outright, which means they have necessarily determined the rights of the case. I remember in the not very long ago, when Congress was upset with a different president, President Trump. I remember not very long ago when Congress was screaming at President Trump for being an authoritarian and misusing his power by, for example, preventing people from crossing the border who didn't have health care, even though the court said that was okay because it was within the statute. I remember a time not very long ago where they were upset with the President Trump because he was exploiting and taking advantage of congressional power. Now, one might think the takeaway lesson from that would be, what if, and here's a deep concept. Are you ready for this? What if we took away power from the executive? Ooh, right? Because we're unhappy with President Trump and his use of this power. That's not what we wanted you to do with that power. It's a really easy remedy, Congress. Really easy. All you have to do is pass a bill that says, these powers, yoink. Because it's obviously too dangerous, because if the wrong man gets elected, he will misuse and abuse it. And now the members of Congress are like, yay, power. Yeah. And voting at this time to deny applications today, Kavanaugh agreed with the court that applicants exceeded the statutory authority. Yeah. To the extent the government urges the court to consider a new application of stay, it should decline the invitation. As the Supreme Court has repeatedly explained, it alone has the prerogative of overruling its decisions, right? This is true whether or not a directive from the Supreme Court can be characterized as formally binding. Vertical stare decisis, both in letter and spirit, is critical access of our hierarchical justice, headed by one Supreme Court, which is why the D.C. Circuit has held, for example, carefully considered language of the Supreme Court, even if technically dictum, which I guess this probably is technically dictum, generally must be treated as authoritative. So just as many courts quite understandably read Chief Justice South Bay's concurrence to guide resolution of constitutional challenges to COVID-19 restrictions, this court should a fortiori do the same with Kavanaugh. Yeah, one might think. At a minimum, the Supreme Court ruling has eliminated a key premise on which this court's state order rested, namely the government at the time had raised serious questions on the merits. Yeah, that's gone. It's now evidence that the CDC extended its authority. Because the government cannot even raise a serious question on the merits, a stay is no longer warranted even under a sliding scale approach. Yeah. I don't blame the district court in the first instance. I don't blame them for issuing a stay. It's very typical and in some ways respectable. It's respectable because, you realize the impact of your decision and you're like, okay, well, I think I'm right, but, before I undo everything unilaterally, maybe the Court of Appeals should take a crack at this. It's a recognition of one's power and limitations there too, which I think is quite admirable. For a district court to say, maybe I, one district judge, shouldn't just issue an order that, controls the entire nation because I'm but one district judge among, I don't even know how many district judges there are. Lots. So it's admirable. But under this situation, even if I would have done what the judge did the first time, and as I said before, I'm not angry at Kavanaugh. I thought it was a reasonable approach. But even if I would have done what the district court did the first time, and even if I would have done what Kavanaugh did, this time around, man, the gloves are off. It's like you have defied the court. You're going to feel my wrath. It's rule number one. It's rule number one of litigation. Don't piss off the judge. Yeah. So, yeah. All right. So that's fun. But we're going to do an amicus brief too, because I saw this and it was hilarious. So we're going to also read this amicus brief, because I'm not done with you guys. For the 139 of you who are currently here, thank you for being here. It's a lot more fun talking to an audience than talking to nobody. And I appreciate that you're here and helping to celebrate that 1,000th video that I've posted. So much law happening all the time. And we can't keep up because, unfortunately, the courts of appeals are like issuing out decisions, and usually more than one every single day. I can't keep up. There's too much law. All right, let's do this thing. All right, this is an amicus brief. Oh, what is an amicus? That's a fair question. What is an amicus or an amici? An amicus or an amici is short for amicus curiae, and it means a friend of the court, which means a lawyer means a group that's not one of the parties wants to opine, right? They would like to offer their thoughts. It's a random group, so it could be anybody. It could be like, the ACLU or NAACP or, the NRA or, anybody who's not one of the parties, but they have some thoughts they'd like to share, and so their attorney will file this. So that's what amici curiae is. We have some thoughts we'd like to share too, as you're considering this. It is a little unusual. It is a little unusual to see amici. In fact, it's a lot unusual, to be quite fair. It's very rare. It is very unusual to see amici in a district court. It's not unheard of, but it's rare. It's more common at the Court of Appeals, and sure, it happens basically every time at the Supreme Court. But for a district court, it's pretty rare. But I guess someone wanted to offer an opinion anyway. So, okay, we got an amici who has some thoughts on this issue. So, okay. All right. So here is what it is. Amicus curiae, the Third Amendment Lawyers Association. There's a Third Amendment Lawyers Association. What do they talk about? Do they have meetings? I have questions. Brief in support of plaintiff's emergency motion to enforce the Supreme Court's ruling and to vacate the appeal. Okay. Waximus says, what's to prevent random people from spamming the court with their own amici? Nothing really. It just never seems to happen. First of all, you need a lawyer. So a person can't do it. You need a lawyer. So that helps a little bit. So, yeah. Yeah. Amicus curiae, the Third Amendment's Lawyer Association, which apparently is abbreviated THUN, ALA. So, okay. The abbreviation for the Third Amendment's Lawyer Association is THUN, ALA. Okay. All right. Hereby files their brief in support of the emergency motion. The CDC moratorium on evictions has a tendency to invade Third Amendment rights. Seriously, though, what do these people talk? Do they have meetings? I'm going to find out. I'm going to find out if they have meetings, and I'm going to go to the meeting just to figure out what the hell this is. Okay. Amicus THUN ALA is a national organization of attorneys who seek to protect and defend the Third Amendment. Because the Third Amendment is not frequently invoked, you think? It is the runt piglet of the Bill of Rights and frequently overlooked. Yeah. The THUN ALA's purpose, therefore, is to advocate respect for the Third Amendment whenever its implications are overlooked. Okay. THUN ALA's stated mission is to educate the public about rights to be free from quartering, advocate for the right in court and legislation, foster scholarship on the Third Amendment, provide a forum for debate and discussion about quartering, and enable supporters of the Third Amendment to contact and assist each other. Okay. THUN ALA's membership is open to any attorney in minutes to practice before the courts. Well, I'm sold. I'm in. I'm going to become a member for at least a year for the THUN ALA just because I can. I, Uncivil Law, am going to join the THUN ALA. Why not? That'll be fun. The parties to this case are litigating the primary issues regarding CDC's extension of the eviction moratorium. Plaintiffs seek to recover possession of their property from tenants who failed to pay rent. Ordinarily, the eviction process would play out in courts. The CDC moratorium prevents this, and they cannot resort to self-help. That's true. Yeah, landlords cannot resort to self-help. They can't, like, for example, cut off the water or cut off the electricity or stuff like that. They can't do that. That's illegal. As a result, plaintiffs are being forced to house individuals, that is, quarter them, without consent. Yeah. Given the size of the population at issue, some of these tenants are bound to be soldiers. It would be helpful if you could identify a couple. I mean, you are the Third Amendment Association, but okay. To the extent the CDC moratorium prohibits evicting a soldier, it runs afoul of the Third Amendment. The constitutional issues warrants attention. You know what? I would definitely, as a judge, issue my ruling partially based on the Third Amendment because it's hilarious. And I'm not beyond having fun as a judge. So, I mean, I won't do it to break the law, obviously, but if I can have fun while upholding the law, I sure as hell will. Because why not? It's entertaining. So yeah, I would definitely issue my ruling, at least partially based on the Third Amendment, just because I can, and because it's kind of hilarious. And because I'd be like, how many Third Amendment decisions have there been? I think like 3 total, and not in any appellate court that I'm aware of. So I get to be one of a very select few. I guess they talk about the same 3 cases over and over again. Yeah, no. The Third Amendment states the following. No soldier shall in time of peace be quartered in any house without consent of the owner, nor in time of war, but in a manner prescribed by law. The Third Amendment protects, you know what's also fun too, because this is just hilarious. You know what's even more fun about it? The Third Amendment hasn't been incorporated. It's never come up, you know? It's never come up. So of course it's never been incorporated. Yeah? It's never been incorporated, so, you know, why not say yeah and get the Supreme Court to incorporate the Third Amendment? Although this is happening, that'd be fun. That'd be fun. Yeah. The Third Amendment protects fundamental rights of Americans to be free from military oppression and masters of one's domain. The Third Amendment is designed to assure fundamental right of privacy. Sure, that sounds good. Has the Third Amendment been to the Supreme Court? I was not aware of that. Okay. Its plain object is to secure perfect enjoyment of greater right of common law, that a man's house shall be his castle, privileged against all civil and military intrusion. The building of soldiers in time of peace upon the people has been a common resort of arbitrary princes and is full of inconvenience and peril. Notably, there's something in the American that repels the right of the sovereign to take up quarters in his house or place of business. It was evidenced by Mr. Jefferson when he penned the Declaration of Independence and complained the king was quartering soldiers in the homes of free people. Coot 33 asks, what does incorporated mean in an amendments context? Aha. Well, actually, I don't know if this would come incorporated or not because we're suing the federal government. So I'm not sure incorporation is strictly possible in this sense. So yeah, but what incorporation would mean is it's applicable to the states. So yeah, the Constitution and the Bill of Rights applies to the federal government because it's part of the federal Bill of Rights. So it applies against the federal government, right? And then the 14th Amendment has been read and understood, and we could go into why, but you know, slaughterhouse, and we'll just call it a day. It's been read and understood to apply to the state, but only in situations where we say it does. So to say a right is incorporated is to say a state like the state of Virginia can't do this. Although I'm not sure if it's possible for the state to do it technically. I don't know. Because do they have troops in the technical sense? Even if they're in the reserves? Actually, the incorporation issue gets more and more complicated with every passing moment. I'm not sure how that would go. It's complicated. But yeah, it would mean it's applicable to states. So I'm not so sure about that incorporation now that I think about it. But we're against the federal government, so we don't have to worry about it. So let's press on. Quartering is a thing to be justly feared. Consider, for example, Joseph Galloway's plea, warning that fellow Americans that rebellion would bring war. War would bring quartering, and quartering would find soldiers traveling over estates, entering your houses, your castles, seizing your property, ravishing your wives and daughters, and afterwards plunging the dagger into their tender bosoms. Ouch. Yeah, I don't know about the National Guard, and I'm not so sure about the state level equivalents either. I don't know. Yeah. The present moratorium states in relevant part, accordingly, the subject to limitations under applicability, a landlord, owner of residential property, or other person with legal right to pursue eviction or possessory action shall not evict any covered person from any residential property in any county or U.S. while the county or territory is experiencing substantial or high levels of COVID. Anyone recognized and permitted by society as founded on lawful occupation or possession, with the legal right to exclude others, is an owner under the Third Amendment. This is coextensive with landlord, owner of residential property, or other person with legal right to pursue eviction or possessory action, which incidentally would include a renter, because I have the right to pursue a possessory action. Now, there's no point in me doing that because I do currently possess it. But if I didn't, right? Soldiers under the Third Amendment includes National Guardsmen when federalized. That's the key there, when federalized. So, covered person, as that term is used in the moratorium, does not exclude any person on the basis of occupation, which then would include a soldier within the meaning of the Third Amendment. Yeah. The moratorium prohibits eviction by owners of soldiers. The use of a house by a soldier for more than 24 hours may be considered quartering. This moratorium is in effect until October 3rd, well beyond 24 hours. This is quartering, and the very nature of the bar against evictions means it's without consent. Yeah, kind of so, you know. When I worked for the Virginia Department of Transportation, we were told we could not park equipment overnight without permission because of the Third Amendment. That's almost certainly wrong. That's almost certainly wrong. Maybe Fifth Amendment for taking or something, but yeah, I don't think the Third Amendment applies to the Virginia Department of Transportation. You know, not unless the Virginia Department of Transportation has some kind of military authority, which I'm going to assume they don't. So, yeah, not so sure about the Third Amendment on that one. Yeah. Yeah. The moratorium prohibits eviction by owners of soldiers. Okay. The only remaining questions are whether this is peacetime or whether wartime has been prescribed. And no. For the purpose of the Third Amendment, the distinction between time of peace and time of war requires a formal declaration of war, which, you know, there's nothing even close to that. Thus, notwithstanding any authorization for use of military force, such is not a declaration of war. I don't think that's necessarily true. And they're citing a district case here for that proposition. I'm not sure that that's legally correct. I'm not sure that there's really a legal distinction between a declaration of war and a authorization of force. And one of the reasons I think that is because, generally speaking, in law, we don't look to like what you call it. We look to what it is, right? So a rose by any other name would smell just as sweet, right? A rose is a rose regardless what you call it, right? It doesn't change what it fundamentally is. So if everyone agrees that roses are now called whatever, then that doesn't change the fundamental nature of it, right? It's still what it was before. So we don't care about what's on the label. We care about what's in the packaging. So I don't think, to my mind at least, it's clear, and I think it probably goes the other way, that an authorization is different than a declaration of war. If you're saying we get to use force against a foreign country, you know, I think that got to be some kind of declaration of war. So, not so sure I agree with the Southern District of New York on that one. Assuming arguendo, the existence of an authorization of force constitutes a time of war. The moratorium was not propounded in a manner prescribed by law. Steven Photos gives $4.99. Shakespeare, Law, and Uncivil, the Friday night trifecta. Woot. You know. The moratorium was not a legislative act. True that. It was regulatory. Regulations may have the force of a law, but they're not exactly law. That's true. There's definitely a difference between something being law and having the force of law. That is true. Right? The difference, if you want an easy example, right? If you want an easy example of something that has the difference between law and the force of law, right? Would be, we can just use the present example, right? The state of Virginia or state of Texas or whatever has passed a law that details how to go about getting evictions. So that's the law, right? And so then you follow that process and then you get a court order, which is not law, but it has the force of law, right? Because the law authorized the order. So it's not law unto itself, but it has force because if you break it, you're in violation of different law. So, yeah. You think they should have added a Fifth Amendment argument? No, Matt. I apologize. Not Matt. I'm sorry. Watching you daily. I'm sorry I confused you for Matt. That's an insult to you. I apologize. But no, I don't think so in this case because it's the Third Amendment Lawyers Association, man. So I think it would be a mistake in this case for them to bring up any other issue. Let the Fifth Amendment Lawyers Association bring up their issue. But we're definitely not going to talk about anything else except the Third Amendment. It's Third Amendment from top to bottom. It's turtles all the way down, man. Internet commentator. That's nice. The moratorium does not actually make any prescription as to quartering. It's a blanket prohibition on evictions. It does not only carve out soldiers, it does not mention them. There's no manner as to the quartering, but CDC does not consider it quartering. Thus, even at times of war, the moratorium is unconstitutional. That's a very short amicus. It's only 6 pages. The CDC pandemic has caused hardship for millions of Americans. The plaintiff? They might have made those arguments before, but at this point, they're asking for... Yeah, I don't think they need to at this point, but okay. Internet commentator says, Senpai noticed me? Of course I did. Yeah, I try to. I try to notice people. Internet commentator, you're great. The COVID-19 pandemic has caused hardship for millions of Americans. What it should not cause is deprivation of liberty. Chief among them, quartering. Thus, the court should allow plaintiff's motion vacating the moratorium, at least to the extent it applies to soldiers. I love this argument. I love this argument very, very much. I love this argument. I definitely want to use this in a decision. I definitely want to use this in decision. So, yeah. So, I think this is right. Okay, now, here's the question. I'm going to let you guys take a poll. All right. So we'll do this in a poll. Do you want me to read the government's reply, even though it is a pile of stupid? We'll take a poll. And while you guys are deciding that amongst yourselves, I'll go get it just in case you vote yes. Fun times. This means I have to find it again. Let's see. Let's see if we can find this decision again. Excuse me. That's what I need. Now I need to get the reply, which is a pile of stupid. All right, so what is the poll? 94%. 94%. All right. I just remember you guys overwhelmingly voted for it. You guys are fun. I will absolutely torture myself for likes. How big is this pile? Well, we're going to see collectively. Nuvi gave me $20. I voted yes because I like seeing you turn red when you read painfully stupid government responses. Well, I'm glad I can be entertaining, I guess. Government answers are always a pile stupid? No, not always. Sometimes the government responses are really, really good. This would not be one of those top, though. All right, let's read this pile of stupid. All right, defendant's opposition. Here's what the U.S. government has to say. How long is this thing? It's only 9 pages long, which says a lot. After the eviction moratorium that was the subject of this litigation expired, the Center for Disease Control determined that deteriorating public health situation necessitated a new invocation of its authority, and responsibility to protect public health. Although the factual circumstances have changed, and CDC's new order differs from the prior eviction moratorium by targeting only areas of high or substantial transmission, which is a practical matter as basically all of them, plans have filed what they style as a motion to enforce the Supreme Court's ruling and vacate the stay pending appeal. This motion should be denied as it rests on the incorrect premise the Supreme Court has issued a ruling in its favor. In early proceedings of this case, the court vacated the prior eviction moratorium but stayed in enforcement. On appellate review, the Court of Appeals refused to lift the stay, and the Supreme Court denied the emergency application. Plaintiffs emphasized that Justice Kavanaugh indicated a concurrence, which implies, they agreed with the position the CDC lacked authority, right? And there are 4 justices who dissented from the application of relief. There are 4 justices who also wanted relief. They just wanted different relief, So, yeah. Under DC... Excuse me. Under DC Circuit precedent, however, the votes of dissenting justices may not be combined with a vote of a concurring justice to establish a binding decision. That makes total sense, because when you concur with the people that are not in dissent, right? A dissenting opinion is just called a dissenting opinion. Whether it's issued by 4 justices or 1, or whether there's multiple opinions, or it's just called dissenting opinion. So yeah, it makes sense that you wouldn't count dissenting votes with the concurring. But you know what you would count? The other ones that are not dissenting. I see 4 of those. So, okay. Waximus says, what more do you want from me? Super chat is always welcome. Just, saying. Until the Supreme Court acts, the court should follow DC Circuit, not predictions about what the Supreme Court may decide. Really, though? Such predictions are particularly problematic here. In the plaintiff's prior Supreme Court application, they offered a variety of bases for vacating the stay, including the downward trends. Yeah, but this is the prior application. In the plaintiff's application, they offered a bunch of reasons. Yeah. The justices who dissented did not explain their reasoning, and may have agreed with the contention that under the circumstances then present, the eviction moratorium was not necessary to prevent the COVID-19, which is a requirement for the exercise. Yeah, but whether the dissenting judges thought that or not, how about the other ones? Since under that time, the trajectory of the pandemic has changed dramatically as a result of a highly contagious Delta variant. And, just for future reference, you can strike out the word Delta, and write in other words, the pi variants, the phi variants, the omega variants, dun, 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 the lambda variants. Lambda doesn't get enough love. The epsilon variants. The 7-day averages of daily new cases is now 89,000, nearly a 7-fold increase when the Supreme Court ruled. And based on modeling, it will trend to include. New evidence suggests the Delta variant is more than twice as transmissible as the original COVID. Circulating at start of pandemic, the Delta variant has demonstrated increased levels of transmissibility. The CDC is once again recommending indoor masking for fully vaccinated individuals. Let me just state this absolutely clearly. Hell no. Hell no. I'm done. Now, I got the vaccine, okay? I got it for several reasons. One, because obesity is a high comorbidity factor, right? And two, because I had very bad asthma as a child, and so it still impacts my lung capacity a little bit. I wouldn't say I have asthma now, but I would say that my lung capacity is slightly impacted, right? So I determined that I was in a high risk pool. I got the COVID vaccine. I thought the science was relatively compelling. I thought, I waited a while, to get it, to see how it would pan out and, see what side effects would be. So I waited a while, and then I thought, okay, this seems to be relatively stable. There doesn't seem to be health effects. I'm at a high comorbidity factor, so I should get the vaccine. And based on my knowledge and information, the rough odds of me dying from COVID, now that I'm fully vaccinated, is 1 in 100,000. And the risk of me having several severe health effects is like 10 in 100,000. So it's like, I'm just done. I'm done with the masking. I'm done. I'm done being imprisoned in my house. I have the vaccine. All y'all can eat me. So, yeah. And Bell asked, did I have any effects of the vaccine? I had extremely mild effects of the vaccine. The second dose was worse. I had no effects from the first dose of the vaccine. I got the Pfizer vaccine, incidentally, because based on my research, the Moderna seemed to have more co-effects. So I don't know if that seemed to be the basis. So I picked Pfizer. And for whatever it's worth, I didn't have really bad ones. I had no impact from the first one. And from the second one, the day after, I had really bad chills. But it was only for the day. And then I felt fine the next day. And it wasn't even for the whole day. It was like for half a day. So about 24 hours after I had the vaccine, I got really bad chills. So I had the vaccine, I think at like 2 or 3 in the afternoon. So like 24 hours later, give or take, I had really bad chills until I went to bed, and then I felt fine the next day. So, and the Pfizer vaccine seems to have slightly higher rate, and it looks like it's about to be fully approved by the FDA. So, I'm feeling validated in my choice. So, yeah. I'm really happy right about now the state of Texas put in a ban against future mask mandates. Because I know the city of Austin wants to put in one. I know they do. We're at level 5 now, by the way. We're at level 5, and that's as bad as it gets. We're in a level 5 crisis for COVID in Austin. Is anyone wearing a mask? Not that I see. The staff is, but no one out on the street, no one going to bars. It's like, we're all done. We're done. Faced with these numbers, and instead of extending its previous moratorium, CDC issued a new moratorium. Under these circumstances, the court should not strike the new order on the basis of the 24-hour of emergency briefing, particularly when plaintiffs had not even filed a plea asserting claims over the narrower order. The court should definitely do this. The court should definitely do it, and I hope they will. Stephanie Pye says, question, did you get the vax because it made you feel safe from the virus, or is it because you felt it was your only choice to get back to normal? I suppose it was a combination of multiple factors, but, I felt like I did my due diligence in terms of researching it. I felt like I did my due diligence and listening to various sources of information. I waited a couple months to see if there were any major signs of major problems from the vaccine, and they seemed relatively low. And as I mentioned, I have some comorbidity factors that are relatively notable. So, it seemed very prudent. So, yeah, that's why I got the vaccine. So. No evidence the vaccine reduces resistance. I'm not sure what you mean. I'm not sure what you mean by that. If you mean it's in terms of health consequences, I'd have to strongly disagree. The evidence seems to suggest contrary to that. All right, so we discussed the prior court hearings, but we don't need to discuss that right now. So the Supreme Court denied the application to vacate by a stay of 5 to 4 vote. Concurring in the denial, no, that's not how that works. Justice Kavanaugh indicated he agreed with the district court and the applicants that exceeded statutory authority, but he was only voting a stay because the plan ended the moratorium. He wasn't concurring, no. The moratorium at issue. On August the 3rd, the CDC issued a new, more targeted moratorium in order to respond to recent unexpected developments, including the rise of the Delta variant. This new order applies only in areas of substantial or high disease and applies through October the 3rd. CDC explained the new order is intended to target specific areas of the country where cases are rapidly increasing, which likely will be exacerbated by mass evictions. As CDC has explained, trends have dramatically worsened since June 2021, and transmission is rapidly accelerating in the United States. A renewed surge in cases began on July 2021. Cases rose from 19,000 to 103,000, with cases expected to rise over the next few weeks. But that doesn't give you new authority. It just doesn't. CDC noted the predominant Delta variant has demonstrably increased transmissibility compared to other variants. And early evidence suggests people who are vaccinated become infected with Delta may transmit the virus to others. Yeah. It further noted that emergency rental assistance has been slower to be distributed than hoped, with hundreds of thousands of applications for assistance currently outstanding, and additional time will facilitate distribution of assistance that could help people in their homes instead of congregate settings where the virus will spread easily. Naughty One says, one thing I want to point out, the CDC and mainstream media are hesitant to address that deaths have plummeted. Yes, they are. And this whole fear porn over the Delta variant is just so tiring. It's just so tiring. Because if you look at the information, if you look at the numbers for the COVID and the Delta variant, looks pretty good. It's not necessarily clear that masks even work with the Delta variant. There's some, and I wouldn't know for sure, but there's some suggestion the virus may be able to pass through a cloth mask. Which, sure. So it's possible. And so but that wouldn't make sense as to why it's more transmissible, for example, if that were true. So, yeah. Just to be clear, we trust the numbers. Well, I kind of always trusted the numbers in terms of the accumulated data. I trust data. I thought the numbers might be slightly inflated, but I didn't think they were massively inflated. I never thought they were massively inflated. I thought maybe they might be slightly inflated, but So yeah, I trust the numbers. They look right to me. They're kind of consistent with what we're seeing around the world, give or take, with enough, with the variance that you would expect from different populations. So, Plaintiff's motion provides no authority for this court to enjoin the order. This DC's motions panel addressed the issue of statutory authority to issue the prior moratorium and conclude defendants had a strong likelihood of success, which, that analysis has changed. It further conclude equity is otherwise favor dependent. Absent a contrary ruling, this court should follow the DC motions panel. No, that's okay. They can overrule me if they want, assuming they even get the chance. 2 people that contracted COVID even while wearing 95 masks. Fair enough. There's no good peer review studies that support mask mandates. Fair enough. I don't think I said that there was. Anyways, I guess I did kind of imply it by saying that the evidence to suggest the Delta variant may not be stopped by masks. So I guess I did imply that masks work generally, but just maybe not for COVID. So, fair enough. A Supreme Court order or ruling in plaintiff's favor cannot be created by cobbling together votes of dissenting votes of justice with a concurrence. The D.C. Circuit has held when lower court applies marks to a certain distinction of fraction court should only consider the votes of justices who support the judgment. Which, you have 4 votes for that. You have 4 votes that support the judgment, right? You just don't have 4 votes that agree to the remedy, right? Kavanaugh writes, I agree it's illegal. Right? He agrees it's illegal. You have 4 votes that would grant it right now, which implicitly means there's 4 votes that say it's illegal. So that means you have 5 votes that says it's illegal. That's a majority opinion, right? And then Kavanaugh says, well, I'm not going to do anything right now. The 4 votes say, well, we do it right now. Kavanaugh says, let it be for now. And 4 justices apparently are saying we won't do anything about it. So, the way I count the votes in marks, The DC's determination the court's judgment should be stayed in contrast was reasoned and was issued by a unanimous 3-judge panel. The court concluded the CDC had made a strong showing it's likely to succeed because the eviction moratorium falls within the plain text. It really doesn't. I read the decision. It doesn't make any sense. Has been recognized by Congress as within CDC's authority? No, that's not what Congress did. It's consistent with the text and structure? No. And it's consistent with authority? No. The DC Court of Appeals is just all the wrong. They're all the wrong and they're idiots. The court further found other equitable factors weighed in favor of the stay. Although the motions panel indicated merits analysis would not bind the merits panel, the merits panel ruling preclusive for all matters decided expressly or by necessary implication. The determination of the moratorium should be left in place, pending further review. But I'll defy the DC Court of Appeals. I'll take my chances. The worst thing they can do is overrule me. So what do I care? The Supreme Court's going to affirm me, so it's fine. And then I'll get to laugh in the DC Court of Appeals face, which is pretty hilarious. District judges are obligated to follow controlling precedents until either DC Circuit sitting en banc or Supreme Court overrules it. Similarly, the court is not free to ignore binding circuit precedent because it's possible inconsistency with an intervening decision. Yeah. Unless and until the court expressly abrogates it, district court lacks authority to conclude. A more recent Supreme Court decision has by implication overruled an earlier precedent. Following to the extent the court disagrees, defendants respectfully request this court enter an immediate administrative stay so the Solicitor General may consider whether to seek emergency relief. There's an exceptionally strong equitable case for leaving the stay of the court. Yeah, so, this all this is part of the rationale. Interestingly enough, this is part of the rationale that as a district court, I want my cake and eat it too, right? I want to simultaneously say it's an extension of the previous moratorium and not an extension of the moratorium, right? Rulings in the alternative, right? It's an extension of the previous moratorium. On the alternative, it's not an extension of the moratorium, right? So that way they can say, well, you were wrong as to this moratorium because of binding authority, but this is a brand new moratorium, isn't it now? So I've not been conflicted with the thing because it's different in manifest ways. Defense respectfully requests the court enter immediate stay. There's an exceptionally strong equitable case for leaving the stay in court given recent trends. No. And the plaintiffs will not be prejudiced by short additional time it would take for the Supreme Court to interpret its own ruling. No. As the D.C. Circuit has observed, plaintiffs waited 11 weeks before bringing their challenge. And every court to consider the questions conclude the prior CDC eviction did not cause landlords irreparable harm. Yeah, but they all said it was illegal. Except for you. Any injury to plaintiff caused by temporary administrative stay is outweighed by the risk of illness and mortality. And moratorium targeting areas of higher substantial transmission, which again is apparently 90% of the population for some reason, is unnecessarily lifted at this moment when cases are rapidly increasing due to the highly contagious Delta variant. The court should deny the motion. This judge has no interest in denying the motion. This judge is very interested in granting the motion. So, yeah. Yeah, try and stop me, man. It's dumb. The moratorium doesn't stop a bank from foreclosure, right? I mean, yeah, it's stupid. It's just a pile of stupid. It's a pile of stupid. So, that's how it goes. Whoa, we dropped to 50 viewers for some reason. 2 minutes ago. We went from 118 to 50, and then we're back up to 80. And now we're back up to 117. Well, maybe my analytics were just not keeping up. I lost a lot of people for some reason. Anyways, yeah. That was pretty stupid. So I think saying this is counting 5. I think you're there, and stop me, D.C. Court of Appeals, and then I get to laugh at you when the U.S. Supreme Court laughs in your face. So yeah. So that is all for today. We've read the memorandum, we've read the papers, and if it were up to me as a district judge, I would definitely be granting the motion. And, come at me, Court of Appeals. You were too mean to big daddy government, so people left? I hope not. A mass changes vectors. It probably does. Yeah. All right, I'm going to sign off for now. This has been fun, and we had a reasonably good audience today, and we had some very good super chats today, actually. Thank you. $75 in super chats. That's not bad. And it does help the channel grow. I keep pouring money into the channel to try to make it better. And, I really, really appreciate it. So, can Scott hold the director of CDC in contempt? Probably not, but it doesn't matter because I just yell at them and make them feel like idiots. So, if you enjoyed this stream, please, if you're not a subscriber already, would you be so kind as to please hit the subscribe button? I would really appreciate it. And then you can help my channel grow. And more people can get wonderful legal education from a lawyer who's like, yeah, this doesn't make any sense. A lot of people out there who might like this content. So, spread the word and subscribe. And also like the video. All those good things. Do the YouTube-y things. Until later, my friends, I hope all's well. Till later, cheers. And goodbye.